Hello everybody, a little bit longer today as I'm going to cover 4 recent property related cases that say some interesting things. I'll rattle through them as quickly as I can. In Barton and Morris, a company called Foxpace wanted to sell one of its properties. A Mr. Barton entered into an oral agreement with Foxpace where if he introduced a buyer to Foxpace who then bought the property for 6.5 million, Mr. Barton would receive a commission of 1.2 million pounds for his efforts. Now hold that figure of 6.5 million. Nothing was said about what Mr. Barton would be paid in the event that the property was sold for less than 6.5 million. The 1.2 million commission figure was comparable to an amount Mr. Barton had already spent trying unsuccessfully to purchase the property himself. Now, Mr. Barton found a buyer for the property for 6.55 million. Yippee for him. But the property ultimately sold for only 6 million following the discovery that it was on land earmarked for HS2 construction work. Foxpace went into liquidation. Mr. Barton brought a claim to challenge the decision to value his debt at a mere £1 in the liquidation, and instead he sought to prove his debt was worth his agreed 1.2 million, his agreed commission. The case went all the way to the Supreme Court, who adjudged that the oral agreement was silent on what Mr. Barton would be paid if the property sold for less than 6.5 million. There was therefore no express term requiring Foxpace to pay Mr. Barton anything upon the sale of the property, where the sale was only for 6 million. The court also adjudged that a term requiring Foxpace to pay Mr. Barton a specific sum in the event that the property sold for less than 6.5 million could not be implied into the contract. It also decided that the Supply of Goods and Services Act 1982, which can apply where the consideration for the service is not determined by the contract and which could therefore have allowed Mr. Barton a reasonable sum, didn't apply here because the consideration for his introduction was in fact determined by the contract. And the court also rejected an argument that Foxpace had been unjustly enriched. Mr. Barton therefore got nothing. I think the moral here is don't agree agreements orally, as was done here, and do ensure that agreements cover all bases. Beware though of committing yourself to a binding agreement in an exchange of emails. Witness Hudson and Hathaway. Mr. Hudson, first name Lee, and Ms. Hathaway were an unmarried couple who purchased a home jointly. Now, they held a beneficial interest in the property as joint tenants initially, i.e. in equal shares. This means that as and when the property was sold, the sale proceeds would be split 50-50. The relationship broke down. Mr. Hudson sought an order for the sale of the property with the proceeds to be split 50-50. Now, some law. Section 36(2) of the Law of Property Act 1925, a joint tenant may release the whole of their beneficial interest in the property to a co-owner and so give the right to the co-owner to the whole of the sale proceeds. And Section 53 of the Law of Property Act 1925, dispositions of an interest in land and of beneficial interests must be made in writing and signed by the party disposing of the interest. Now, Ms. Hathaway agreed to the sale of the property, but she claimed she was entitled to the whole of the sale proceeds. And this was because she was relying on previous emails exchanged with Mr. Hudson regarding the financial arrangements and allocation of assets following their separation. In those emails, the couple agreed Miss Hathaway could keep the house and all of the sale proceeds on the basis that she would relinquish any claim she had to Mr. Hudson's other assets, pension, shares, etc. and the Court of Appeal held that those emails were binding on Mr. Hudson. They were in writing, of course, they were emails, and they had been signed by Mr. Hudson as he had deliberately typed his name, Lee, at the bottom of those emails. So Section 53 of the Law of Property Act applied. Therefore, he'd released his beneficial half share to his estranged partner, Miss Hadaway, and she was entitled to the whole proceeds. Now, that's a residential case, but I think the lesson here applies equally to commercial, which is that the parties must be careful when discussing their property interests informally. Signing off an email with even a first name can be sufficient to comply with the statutory formalities for transacting property. And there doesn't need to be a flowery email signature or one imprinted with email software. In both cases here, the law treats as authentication of the content of the email by way of signature. If entering into email exchanges that agree property transactions, do mark them subject to contract. In Vistra Trust and CDS Superstores, B&Q, who were the tenant of a retail unit in Widnes, had a break clause in their lease that required it to give the landlord not less than 6 calendar months prior notice in writing to terminate the lease. Well, B&Q served a break notice in which it actually gave the landlord 4 years and 2 months notice. It subsequently assigned its lease to CDS Superstores, who wanted a 1954 Act renewal lease, but the court held that the break notice served by the assignor tenant B&Q was effective, and it could see no reason to imply a term to the effect that the notice had to be given only a reasonable time before a date that was 6 months before the break date. Break notices are irrevocable, and CDS as assignee was therefore bound by the assignor B&Q's break notice, even though served such a long time ago. In B&M Retail and HSBC, HSBC was landlord of some premises let to B&M under a 1954 Act protected lease, but they wanted B&M out at the end of the term, having agreed to let the premises to Aldi for Aldi to redevelop, conditional on vacant possession being recovered from B&M. So HSBC as landlord needed to serve a counter notice to B&M's Section 26 request for a new tenancy opposing renewal on the grounds of redevelopment, but they failed to do so because of a postrum error apparently. So HSBC as landlord was unable to oppose B&M's lease being renewed, but they sought a renewal lease from the court on terms that would allow early VP on the grounds of redevelopment and thus allow their proposed deal with Aldi by the inclusion of a break clause in the renewal lease, allowing the landlord to terminate on the grounds of the premises being required for redevelopment. Now, the court heard from experts from both parties in relation to planning prospects, and it agreed with HSBC's expert that there was a real possibility of planning permission being granted for Aldi's redevelopment. And so the court held for the inclusion of the redevelopment break in the renewal lease in HSBC's favour, therefore effectively rectifying HSBC's mistake in not serving the counter notice. Now, B&M argued that allowing the renewal lease to break for redevelopment would have significant financial implications for their business and for local jobs, but the court decided that HSBC's wish to allow Aldi to redevelop the site would trump B&M's position. The 1954 Act should clearly not be used as an instrument to defeat redevelopment. Now, it looks like it's being appealed, that one, so we'll keep our eyes peeled. That's all for today. Thank you for listening. Enjoy your 2 bank holidays. Gather ye round your cathode ray tube television sets with your cucumber sandwiches and enjoy the coronation. And I'll see you in a fortnight's time.